Hi, I'm Katie Harris. I'm a senior associate in Boyes Turner's employment team. This employment podcast series is going to be looking at different elements of corporate support work that we do as employment lawyers, which is fundamental to any corporate acquisition. The series is going to be aimed at HR professionals or anyone involved in business acquisitions who might have an interest in the legal aspects of buying and selling businesses from an employment perspective. In this opening episode, we're going to go back to basics and look at the two different types of business acquisitions, what the differences are, and what that might mean for people within that business. I've been speaking to Chris Dobson, who is a partner in our corporate team. I wanted him to give a bit of insight into these transactions from a corporate perspective. I started by asking Chris to tell us about the two different types of business transaction, share purchases and asset purchases.
The first one of the company sale or a share sale is where the target company itself is sold. And the other option is a trade and assets sale where the company will be selling off its business and its assets directly. The circumstances that might apply will vary, generally speaking, in accordance with who the buyer is going to be. So the classic transaction structure is that it will be a trade buyer. So perhaps a competitor of the target company or the target business coming in wanting to take it over. Other times you might find that it's a management team that are going to be acquiring the target company or business. And that team might be made up of a mixture between existing senior employees within the company.
One of the things that I often find, when talking to people is that they don't really understand the distinction between a share sale and an asset purchase. And I know you sort of said at the beginning, a share sale is when the company itself is sold and an asset sale is when the company's assets are sold. But what's the actual real difference between those two?
When we talk about a company being sold, what we mean is that the shares in that company are being sold by the shareholders who own that company will sell their shares to the buyer. And what that means in practice really is that from a kind of business operational perspective, it's a kind of a clean exit, because from the perspective of the company itself, all of its dealings with its customers, with its suppliers, particularly from the perspective of this podcast, I guess, employees, nothing changes because, the relationships are still with the company. All that's happened is that the ultimate ownership of the company itself has changed hands.
And so in what type of circumstances would a buyer of a business want to acquire a company via a share purchase?
The key driver why you might want to do that is it's, and I'll kind of preface this by saying that if you are acquiring the shares in a company, it's very important to appreciate that as a buyer, you are taking on all of the liabilities that come with that as well. Because as we've just said, from a customer, supplier, employee perspective, nothing has changed. So the buyer, you're coming in, you're taking on those liabilities. But crucially, and why it's quite an appealing option for buyers sometimes, is that because of that the connection, as I say, with third parties isn't changing, it simplifies some of the legal processes. So, for example, you have that key customer that you want to make sure that you secure. If you're just taking over ownership of that company, once you've completed, that relationship still remains in place. You don't have to do anything from a legal perspective. You've inherited that relationship. The company is still sat there as a party to the agreement with the customer. And again, key to you guys, as you're well aware, Katie, I know, is that, again, the employees, day one after you've completed, are still employed by the company.
Yeah.
Nothing has changed from an employee's perspective and from the employer's perspective.
So looking at asset purchases then, I mean, we talked about how, with a share sale or share purchase, the company stays the same, nothing changes, it's literally just the owners. When we're looking at an asset sale, that's very different, isn't it? So when we're talking about the business and the assets of the company and that gets sold, what does that actually look like in practice? What do we mean by that?
Yeah, so the key thing is that if you're looking at an asset sale, A buyer might be looking to go down this route because they might look at an overall business, and they might only fancy some of it. From a buyer's perspective, that's quite appealing, because if you go down that route, it might also be that the parts of the business that you don't like the look of so much might also have some liabilities attached to them. And if you don't pick them up, you're not then taking on that liability as well. So you're just taking the good stuff really that you're interested in. But the big kind of technical point to bear in mind in that process is, as we've touched on earlier, is that if you're acquiring a key customer of the target business, what's going to happen is that the existing contract is going to need to be transferred from the name of the target, the company that's selling it, into the buyer's name. And that process is assignment. And it's quite labor intensive, really, because if your advisor's looking at these contracts from the buyer's point of view, you've got to look through all of the contract terms, and it might not be as straightforward as transferring it across without any issues, because it's very common to find that certainly big supplier contracts, there will be restrictions on the ability for either party to assign their rights under the contract to a new buyer without potentially having to get the express consent of the relevant customer, for example. So that's a big process that we have to look at when looking at business sales, is going through all of the terms and conditions that apply to the contracts that are going to be going across. And of course, the other big point is going to be cheapy.
So just quickly stopping there, for those of you that may not be aware, Chris has used a term there called cheapy. Many of you listening to this may already be aware of what cheapy is, but just in case you don't, cheapy stands for the Transfer of Undertakings Protection of Employment Regulations. And it's basically a piece of legislation that seeks to protect the employment of employees who are in a business that gets bought by another company, but it only applies to asset transfers. And what it does is it just automatically transfers the employment of those employees to the purchaser, protects their terms and conditions, and places a number of restrictions around what you can and can't do with those employees after the transfer. But we will go on in this podcast series to focus a little bit more on cheapy later on, but just wanted to give a quick brief explanation of what that was in case people weren't aware. What's the typical process then? Once you've agreed an initial price and you've decided on your method for the final valuation before completion, what's the first step in kind of actually starting the process of buying the business?
So the first step may or may not be the parties enter into heads of terms, which are, they're actually kind of mainly not binding legally, which is an interesting point. But the parties on some transactions quite like to sit down and put down on a couple of sides of paper the key terms that are going to apply to the transaction. Like heads of terms, sometimes you have them, sometimes you don't, but you will always have a process where a buyer will then carry out its due diligence inquiries. But yeah, this is in the form of a buyer sending across to the seller and their advisors a very long list of detailed questions, which are aiming to uncover any potential issues that might be sitting in the company or in the business that they're going to want to have a handle on and understand. The key thing to walk back to is the fact that in a business acquisition, you're not necessarily buying everything. And in our legal documentation, we've been very clear that if there's an area of the business that we don't want, then that's very much definitely excluded from the premises of the transaction. And the paperwork will be clear that any and all liabilities that sit behind the assets that are not coming across, they're definitely staying put with the sellers.
Okay, so we're going through the DD process, and what part of that process is a high level overview, Chris. What sort of areas are we looking at as part of DD?
So we are very interested, obviously, if it's a shares acquisition, we're very interested in who owns the shares. Do we have certainty that they are the only shares that are in order to take ownership of the company? Do we have any individuals that might have options over shares, which mean that down the line someone has the right to be issued shares in the company? So we want to make sure that we're securing total ownership and control of the company. We're also very interested in contractual matters. As I say, who are the customers, who are the suppliers? Can we have sight of all of the relevant terms that apply to effectively the revenue driving parts of the business. That's going to be key. So we need to know about the contracts that are in place. We are very interested about intellectual property. If the business is utilizing branding or it's using websites, domain names, if it's got particular funky software that's bespoke that it's using, we need to know all about this. We need to know who owns it, or whether it's being licensed, who is it being licensed by, who's that third party, any potential claims, disputes around all of this area. Very interesting. Data protection, as you can imagine, again, in your area, it's key to make sure that we're not facing a situation where thousands of third parties have been inundated with spam as part of the business. We're going to have issues there. Employees, absolutely key, absolutely integral to any DD process, ensuring that we've got a handle on who's an employee, who is a consultant, who's potentially kind of sitting somewhere in between, which makes us concerned about our obligations to them going forwards, whether it's pensions, whether it's holiday pay, all of this good stuff. Very interested in that. Property as well. We need to obviously understand whether we are inheriting leasehold interests. Where are we? Where are we going to be working going forwards? Does the company own any freehold property that we need to be aware of? And are there going to be any environmental concerns linked to that? Again, depending on the sector.
A lot of the DD process and a lot of the focus on it is driven by the buyers, kind of what they want and what the reasons that they're acquiring the business for. When do you start having those conversations to identify what their primary purpose is for buying the business, and to what extent does that feed into your approach to DD?
Yeah, I mean, the answer is very early on, as you can imagine, Katie. So part of my role is to understand, we're acting for a buyer, obviously, in this context. It's really important for us to understand early on, as you say, that the commercial drivers behind them wanting to carry out this acquisition. What is it that's attracting them to the company or the business they're looking at? And do they have any immediate concerns, areas of importance or risk that might be in there that they want us to look into in more detail? Yeah, and again, equally on the flip side, it might be that there's areas where there's going to be less importance. They don't need us to be spending so much time looking in these certain areas.
When we go through the DD process, obviously the whole purpose of that is to identify are there any sort of hidden liabilities or things sitting within that business that we might not like or we don't want or what have you. Let's say we identify those sort of liabilities. What do we do with that? How do we address them?
This all really, it comes back to the main document in the sale and purchase process is going to be the SPA, the sale and purchase agreement, which we can talk about it in a moment, but amongst many other important points in the transaction, one of the key areas that it contains is our list of warranties that the sellers will be required to give. And really, these are kind of rehashing the same questions that we're asking in due diligence. A buyer is looking to protect itself by throwing into the mix a long list of warranties, which are effectively statements of fact about the target company or business, which, if they're then proven to be false or incorrect, it gives you as a buyer an ability to bring a contractual claim against the sellers in damages. So the classic example would be a warranty to the effect that the company's not being sued by any of its employees from fair dismissal at the point when we complete. If we complete the deal with that warranty in the agreement, nothing is said by the sellers. And then 2 weeks down the line, we find out that actually there was a live claim from the company's FD, whatever, or whoever. And actually that claim is worth £1 million. And that claim is ultimately successful. As the buyer, you've then got a clear pathway to go back to the sellers who sold you that company, who sold you that liability, didn't tell you about it. And you're going to go back and you're going to sue them for that £1 million that you've suffered, plus all the associated costs involved in that process. You might choose to walk away from the deal completely. You might choose to go down the line of presenting a price chip to the sellers to be saying that we'll still do the deal, but again, that initial valuation that we looked at a few weeks ago, that was on the basis that there wasn't this stinking claim in the mix. So actually we're going to bring that valuation comes down now to reflect the potential liability that we're facing here. Or what you might do is, as a buyer, you might say, yeah, well, you might want the price chip anyway. You probably want that. But you're also going to go back to the sellers and say, okay, we want an indemnity to cover this point, because whereas, a warranty is there to potentially kind of flush out potential issues, and it gives you comfort if there was something there that you weren't told about. An indemnity comes into play where there's an identified issue. You know that there's a problem here as a buyer. In which case, the way of looking at an indemnity is effectively it's almost kind of a blank check being written by the sellers to say, saying to you as the buyer, look, if we complete this transaction, and if ultimately that claim from our former FD comes home to roost, then we'll cover you for that as the buyer.
From a seller's perspective, if you sort of get a big long list of warranties, and you're looking at these and you're thinking, oh, I'm not sure. I can think of something within the business that means that we can't give that warranty, or what mechanism is there in place to kind of deal with that? What should sellers do in that position?
Yeah, so what sellers will do there is they will provide a disclosure on that point to the buyer. So sitting alongside the main SPA document is going to be the seller's disclosure letter. So effectively, what this is doing is providing an opportunity for the sellers to provide the buyer with formal disclosure of any facts or circumstances which in any way contradict the warranties which are set out in the agreement. And it's a really key point for any seller to understand is as much as they might be having casual conversations with the buyer at some point during the negotiations, or they might have told the buyer about certain nasty issues during the due diligence process. From a strict legal perspective, that's almost irrelevant, because unless the formal disclosure is made in this disclosure letter, the buyer has got the potential to try and argue the fact that they weren't actually aware of this particular nasty matter. And the only way for a seller to make sure the buyer is formally on legal notice is to include this, the disclosure itself within this letter. So therefore, as long as the disclosure itself is being properly drafted and is crafted with enough detail to ensure that the buyer can't reasonably turn around and say, I wasn't given enough clarity or wasn't given enough detail. If you're able to make sure that you are, crafting it in a way which does tick all of those boxes, then, as I say, it removes the ability for the buyer to bring a claim in damages after the event.
So as a seller, it's really in the seller's interest to disclose as much as possible then. That, because I can imagine some sellers might be sort of sitting there thinking, oh, I know about this horrible thing in my business. I hope they don't find out about it. But actually, the more information that a seller can give. Yeah.
100%. Yeah, absolutely. And, my advice to any seller going into the process is, work with your lawyers to make your lawyers be the ones that give the judgment on whether or not something should be disclosed.
Because there might be a concern that if they make a disclosure, that's going to result in an indemnity. I mean, is that typically what happens? Or I mean, how common is it to use indemnities?
Yeah, I mean, how long is a piece of string? I guess really, Katie, it's very much on a kind of a deal by deal basis. I would say, generally speaking, that if a seller is well advised at the outset to the point where their lawyers are able to provide all of the required information that a buyer might want around a certain issue, that is going to help. In the majority of cases, it's going to mitigate, if not remove, the need for an indemnity, because actually, if there's proper advice at the outset, it can be looked at, and the buyer can have total clarity as to what the potential risk is. And as I said, in many cases, actually, it gives the buyer comfort that that there is a potential issue there, but it's being handled appropriately. And on the basis of the lawyers now having a look at that, we can take a view on whether or not it really is a material risk or not. The other element as well, there might be cases where it's just unavoidable. There is a big issue. It does requiring an indemnity, unfortunately. But again, if you're being well advised on the sell side, it's possible to negotiate a series of protections under the sale and purchase agreement, or effectively give you a bit of comfort and make it harder for a buyer to come back and make a claim down the line. So, basic headline limitations might be the fact that you negotiate a threshold of loss that needs to be hit before it's actually possible for a buyer to make a claim against the sellers. So that, it removes the possibility of, a kind of a low value issue coming home after the event and the seller's being bothered by that. So, a decent lawyer will be able to negotiate a materially high enough number that means that the sellers can kind of sleep at night without being worried about low value claims coming home. The other key one will be a time limitation mechanism. So again, as a seller, you want to avoid being in a situation where you're bothered by a buyer, maybe 3 or 4 years after you sold the company because an issue has just kind of kicked off at that point in time. Again, if a decent M&A lawyer for a seller will be able to negotiate a time period which again reduces the likelihood of claims coming in after the event. And there's many more, loads more kind of limbs of limitations that we can.
But you can cap. I mean, is it common to kind of cap the level of liability under an indemnity as well?
It can be. So, again, on a case by case basis, this is where you and I work very closely, as you know, because certainly where we're looking at employee related issues, where your expertise lies, Katie, is that you can look at that and you can assess the circumstances. And you're able to quantify the top end of potential liability that will be associated with that claim. Obviously the factors sitting behind that, depending on the employee in question, how long they've worked in the business, case law, all of that good stuff that obviously you're an expert on. So in that situation, that's where we as sell side lawyers in this instance can then reasonably go back to the buyer and say, look, it's not reasonable for you to have an uncapped open-ended indemnity on this point.
So we've talked about warranties and indemnities and the way those are used in the SPA to deal with liabilities and risks that have been identified, basically. What other, sort of just very briefly in high-level terms, what other things are included in the SPA? What else?
Yep. So the payment mechanism itself, obviously, as we kind of touched on earlier, that's key for the sellers. Obviously,
they want their money.
The amount they're going to be. Yeah, exactly. The amount they're going to be paid and how and when is it going to be paid. So obviously, if you're a very fortunate seller, you might find a buyer is prepared to pay you everything on day one. Fantastic. That does happen. It does happen. But probably more commonly, you'll be in a situation where the buyer will agree to pay a certain amount of the overall purchase price on completion. And then there will be some deferred elements. So it might be that you receive 50% on day one, and then you receive 25% after a year, and the balance in 25% year 2, something like that. Although, very commonplace, we will have deferred payment mechanisms which are dependent on the future performance of the company or the business that's been acquired. So these are called earnout mechanisms. So this is again, it's where we work quite closely in part because if you're a seller, you've obviously got very vested interest in the company or the business that you've sold continuing to do well going forwards. And the buyer equally is going to want you to stay in control because you might be a key part of that. And so we're in situations very frequently where sellers are, they've sold up, they've lost their shares at completion, but they retain an interest going forwards because as long as the business does well and it hits certain thresholds, they're going to receive even more money as a result of the deal. But the balancing act we've got to find then is that going forwards, these individuals have gone from the founders, the shareholders, to mere employees, in relative terms. So we need to make sure that they're protected from being unreasonably kicked into touch and let go before the end of their earnout period, and then potentially losing the ability to dictate the performance of the company going forwards. So that's another really interesting area.
Yeah, but I mean, that's going to benefit both sides, though, isn't it? Because you're then, if those individuals are still in the business, and it's going to give this handover, process, and it's going to mean that the business hopefully would be more likely to achieve those targets as well.
Yeah, That's right. I mean, I find it a really interesting area to negotiate because you're quite right. It's actually, it makes no sense for a buyer, however evil they may be depicted sometimes, to want to come in and kick out a seller who is helping to grow revenue going forwards, just as a way of trying to get out of paying them some additional cash under the earnout. Because again, these earnout mechanisms are structured on the basis that, although the sellers are going to receive some more bumps as part of this, ultimately the buyers are doing even better because, they've acquired a company which is really flying and generating loads of cash. So it's a really interesting area, and but it does come into it does throw into the mix considerations about making sure that these individuals aren't going to be deprived from making decisions which are going to have a key impact on driving performance going forwards. So that's a really interesting area. So we do that a lot. It will also contain restrictive covenants, a big point as well, because obviously from a buyer's point of view, you don't want to pay someone an awful lot of money and then find out that a week down the line they've gone off and have set up a competing business just down the road. Presumably
as well, there's lots of ancillary documents that go alongside an SPA. So you mentioned property earlier. I mean, and the need to assign commercial contracts and things like that. I mean, are there sort of other documents that are needed as well?
Absolutely. So we've got kind of basic form ancillary documents that go alongside the main SPA and the disclosure letter. So stock transfer forms, new share certificates, board minutes, deeds for lost share certificates, all sorts of kind of fundamentals like that, alongside other more bespoke agreements that may be required. So, I've mentioned it a moment ago about individuals who will remain employed going forward. So it's very, very commonly we're going to need to have new service agreements or consultancy agreements drawn up and put in place at completion. Again, it's relatively common that you might find that certainly in the scenario of a business acquisition, the buyer may need to hang on to some of the existing infrastructure that the seller was providing pre-completion. But so it might be HR functions, it might be IT teams that continue to need to service that business after the event. So we'll have transitional service agreements covering all of that. Yeah, and with property, you touched on that a moment ago, we might need to have new leases, or we might need to vary existing leases. So yeah, it's why I love what I do, because it varies from deal to deal.
Yeah. And it's I think one of the set overriding senses from this conversation is that, I mean, it's fascinating, but it's also extremely complex, the process and to make sure that we get this right for the clients, whether we're acting for buyer or seller. I mean, and again, this is probably going to be a how long is a piece of string question, but I mean, how long does a typical acquisition take from start to finish? I mean, is there an average? I mean, I suppose it varies widely, but
it can do. I mean, look, in the interest of giving you an answer here, maybe it's a bit lazy. In my experience, transactions within the kind of mid-market level that we operate in, I think you can expect somewhere between kind of 2 to 4 months, typically. Obviously, with exceptions either way.
Very quickly, top tips for buyers and sellers.
It's all about who you instruct as your advisor, not just as a lawyer, obviously, but who you instruct to look at your numbers as an accountant or a corporate finance expert as well. The reality is that if you're a buyer or a seller, it's a very intense process, and you need to make sure that firstly you're working alongside advisors who you don't hate because it's not someone that you're going to dread having to speak to.
And you're going to be speaking to them a lot.
Yeah, you're going to be speaking to them a lot. So it's got to, I appreciate no one wakes up wanting to speak to a lawyer in particular, but you have to accept the fact you will be doing that. And also making sure that you do choose genuine specialists. It's quite easy if you're going to this for the first time to just kind of shop on price and then expect them to know what they're doing. And I've seen it before. The reality is sometimes you're going to have people that don't necessarily have the relevant level of experience, which frankly has resulted in them not giving a realistic quote of how much time and effort is going to be involved. And it does unfortunately then slow the process down and opens up the possibility of risk for both sides, because an inexperienced advisor is not going to be well placed to spot potential issues that should be disclosed.
And I think having that relationship with your lawyers as well, so that, you know, they really know and understand and get your business and the sector that you operate in as well, is so important, particularly when you're dealing with acquisitions like that. So that, you know, the advice can be targeted, pragmatic, commercial.
It's absolutely key, Katie, because again, you know, increasingly we're finding that clients these days, their expectation, quite rightly, is that, you know, you work with advisors that know the law. You know, that again, that should just be a basic hygiene point. What then stands out, you know, from normal advice to great advice is a lawyer that is then able to apply their legal knowledge and experience in that given commercial situation or the sector space that they're aware of, that, you know, they know the ins and outs of it.
Yeah.
And, you know, ultimately I look at this, a client is not paying you because they want to enjoy the experience of being lectured at and want to be involved with very long, tedious legal arguments. You know, they've got an objective to hit, and it might be that objective is to buy that company, or their objective is to sell that company and go off and retire and enjoy their life. And really our role, all it needs to be is to work with those clients to ensure that objective is hit as seamlessly and as easily as possible.
So that was Chris Dobson, partner in our corporate team, with his insights into the world of corporate acquisitions. In the next episode of this series, we're going to start looking a little bit more closely at the different types of acquisition that Chris was talking about, sale and asset sales. The focus will be on the employment aspects of those and the different considerations from an employment perspective that we have to have in relation to each. Just subscribe or follow the podcast and you will be able to listen to the episode as soon as it is available. Thanks and goodbye.